Great. Well, welcome back, everyone, and good to see you, Susanna. We're going to miss Jordy today, but cover off some of the topics that we started to cover off last week.
Thank you.
All right, we're going to stay in the theme of power of attorneys, and in particular, we're going to focus on powers of attorney for property. And in line with the slides that we started with last week, we sort of paused last week at the point of talking about the duties of an attorney. And this is the less tangible aspect of the job, and the more common law based elements of it, because we've talked last week about the fact that the statute is essentially a codification of many of the aspects of being an attorney, both in regard to the test for capacity and the like. But as the Substitute Decision Act is so good about, we also have a Section 32 of the SDA, which talks expressly about the duties of an attorney for property, and the requirements are set out in that provision. And so again, nice to always have direct legislative guidance when we're considering some of the fiduciary obligations and duties that an attorney has to consider. And of course, Section 32 deals with the duties of a guardian, but quite properly apply to powers of attorney for property as well. And so the primary goal of any sort of consideration of whether or not you have met the parameters of what you're expected to do as an attorney for property and a guardian of property, it continues to be the focus by the courts anyway, continues to be whatever you're doing must be in the best interest of the incapable. And from that standpoint, you see many decisions that sort of focus on that language right at the outset, because that tends to drive all of the expectations of the courts. But the express provision of Section 32, of course, Susanna, gives us some direct guidance as well for guardians.
Yeah, I think, the thing that I've always surprised by is that certainly the obligations and the duties of a guardian are very, very onerous. I mean, we're talking about someone who is a substitute decision maker, and as you say, they're required to act in the best interests of the individual. And, I always find it surprising that when people are executors, so when someone passes away, most people will go to a lawyer and get some advice in terms of how to administer an estate. Whereas with the power of attorney, I find it very, very rare where people will go to a lawyer and get some advice in terms of how to be a good attorney. And so I think, that the fact that there is a codification certainly in the legislation is great, but for the average person, they're not necessarily going to go into this eyes wide open knowing what's going to be expected. And so given that it is such an onerous job, it's something that we should be certainly trying to encourage people to get advice, because yes, the legislation is there, but you've got to know what to look for. And it's not always top of mind for someone who's stepping into perhaps a crisis management situation where they're just trying to do good for goodness sakes and help an incapable person through a very difficult time. And then at the end of the day, someone can just criticize that with the benefit of hindsight, and it just doesn't seem fair.
Well, that's right. And the starting point of these considerations, the statute, because it talks about right at the Section 32 sub 1 talks about the fact that it's a guardian of property is a fiduciary, and that's an express comment. At some point in time, the question of agency and fiduciary was sort of toyed with. I know in the Hansard, I've read some of the Hansard discussions about this, and at the end of the day, they expressly put in the word fiduciary for a reason. And so we're creating fiduciary obligations, of course, and it's honesty, integrity, good faith, all in the benefit of the incapable. The other part of it is, of course, Section 32 1.1, which goes right to the question of priority of what the courts are looking for when we're acting in this role, and that is to maintain the personal comfort and well-being of the incapable. And it's no mistake that is the primary obligation of an attorney, both in personal care and property.
And you can see how if two different people have those particular roles, it may create a conflict. And so the fact that the statute specifically says that that should be top of the mind for the attorneys is something we really want to make sure that they're aware of, because it is very important.
And section 1.12, which talks about personal care of section 32, also gives guidance in respect to the fact that it talks about the guardian shall manage the person's property in a manner consistent with decisions concerning the personal care that are made. So it's that's always the linking up that needs to be done, and that's set out right in the statute that both the personal care and property attorneys can't work in isolation. They need to be like I always use the example that sure, if the individual incapable would like to stay in a home that's $30,000 a month, that might be the best personal care choice for that individual. But the property attorney is going to say, well, we don't have $30,000 a month, maybe. And so they obviously, that's just an easy illustration. But the coordination between the two is crucial. And there's, of course, some exceptions to this, because of this doesn't apply in a decision concerning a personal care if the decision's adverse consequences are significantly outweigh the personal care, the person's personal care. So, the court obviously, the legislation obviously gives us some flexibility, but combining the two, coordinating the two is crucial. The next area, of course, Susanna, is participation and the provisions in the statute that deal with the expectations of participation of the attorneys.
Yeah. Certainly. The expectation is that, we're going to seek, if we're an attorney, we're going to seek the supportive family, friends input on things, so as to make sure that, we're acting in the best interests of an individual based on their prior expressed wishes, and having the participation not only of supportive family and friends, but also, pardon me, the incapable person themselves, to the extent that they can voice things and express themselves. I think that's really important. Don't forget that there's still a living person there that is going to have some thoughts and some input on it, and we've got to take that into consideration.
Well, and exactly. And, when you're, I always say to my clients, the way I look at, to be the best dutiful attorney, you need to look at what the courts criticize attorneys for. And they literally will go through section 32 and the headings and criticize an attorney if the facts are relevant to it on these headings. And participation with family and friends is a crucial one. The next one, consultation, of course, that the guardian needs to consult with the family and friends, which you already identified, but also the person whom the incapable person receives personal care as well. So these are strict codified duties and expectations that the legislation identifies. Susanna, probably the most difficult and probably least prepared element of the duties ties to accounts. Want to talk a little bit about the legislation, and then of course the standard of care that is expected, because there's a good question I'll come to after that.
Yeah, of course. One of the greatest duties and responsibilities of an attorney is, of course, to prepare their accounts. So they're expected to be maintaining them right from the outset and be ready to produce them upon a request by anyone for them who's authorized to actually ask for them. So it's very high onus that arises just from the moment that you start acting. And the standard of care, of course, is going to be informed by whether or not at the end of the day an attorney is looking for compensation. So if an attorney for finances is going to seek their entitlement to compensation at the highest level, then there's going to be held to the highest standard. And so that certainly, when you say we're looking at considerations of the court, that's going to be quite an important one. And the standard is someone who's going to be expected to exercise the degree of care, diligence, and skill of a person of ordinary prudence and how they would exercise that responsibility in their own set of circumstances. So, it is an objective test, and it is going to be formed by, of course, the best interest of the incapable, but something that's going to be reflected throughout their term, because they're going to be held accountable.
And the standard of care also, the legislation specifically says, section sub 7 and sub 8 talk about the unique ability of the court to be able to be less critical or less, the expectations can be higher or lower depending on whether or not you take compensation. Do you want to talk a little bit about that, Susanna?
Right. So when there is a claim for compensation, then the guardian or the attorney is going to be required to exercise the degree of care, skill, and diligence of a person who's actually in the business of managing the property of others. So it elevates that standard to someone being, again, in the business of doing it, as opposed to someone just doing it, for goodness sakes, in a sense, and trying to help someone out.
And so, that's a decision that has to be made with the client if they want to, if they're going to, at the end of the day, get audited, or they're going to be attacked in any way, shape, or form. You can always use that card to soften the blow.
Mm-hmm.
The other part of this, of course, is the whole question of managing assets. And I note that section sub 12 of section 32 expressly says that the Trustee Act does not apply in the exercise of a guardian's power or performance of a guardian's duties. And so we've got the obligation to account, which is obvious, and that we can talk about that a bit more for sure, but that's the Rule 74 in Ontario, expectations under the courts for court format audits. But this secondary point of investment, like what do we do about investing in our in the assets of an incapable, and what does it mean, of course, when they expressly exclude the Trustee Act? Susanna, what are they getting at there?
Well, they're getting at the, I'm presuming you're going into this, the
prudent investor rule is, of course.
Thank you. That's it.
Yeah.
Yes. And the fact that, under the Trustee Act, we're expected to diversify, and we're expected to act as a prudent investor. But I think there's a recognition here that, when we're acting as an attorney, it's a little different. The onus is different. The responsibilities are different. And again, just to be able to do your job as good as best that you can, the importance of seeking some kind of legal advice in terms of how to deal with the investments and how best to manage the assets, I think, is pretty important.
Yeah, and so there's a whole bunch of case law on this point of investments, because too often attorneys get into situations where they are managing the property as though it's going for the estate as opposed to going to the incapables. And why we started off the podcast tonight was with this primary foundational goal of always in the best interest of the incapable. Well, the investment scheme itself is always in the best interest of the incapable to actually be in cash and not in a diversified portfolio, because you, in theory, want whatever assets are there for the safe and exclusive benefit of the incapable. So you can actually get criticized for having put it into a balanced portfolio, exposure to criticism for putting it into a balanced portfolio. And in large part, it's driven by this idea that section sub 12, the legislation specifically excludes the Trustee Act, and that's been treated by many of the courts to say, well, then you need to rethink your investment portfolio for an incapable, and it has to be driven by the economic interests of the incapable, not whatsoever who are ultimately going to be the heirs.
Mm-hmm.
So we've got, core elements of the Act set out what are the fiduciary duties that we all see in any fiduciary role, and that is, for of course, a duty to account, the duty to properly invest, and in this case, in the light of the exclusion of the Trustee Act, and the duty to communicate. We have a question it's a great question that takes us to the next element of the duties for an attorney, and that is the question of self-dealing. So under the question that was raised in the chat is of course, what if there's lots of money? Can we start dishing out the dough early to the beneficiaries? Because as an attorney for property, you do have an obligation to get a copy of the will. And so you need to know what the will is going to provide for, because that does drive, for other reasons, that does drive your decisions in terms of maybe in terms of distributions, but certainly in terms of if there's a special asset that's already been allocated in the will, whether or not you would liquidate it or not. And there's some provisions under section 33 that gives us some exceptions to that. But the idea that at the end of the day, a trustee, an attorney has the obligation to avoid self-dealing is an obvious one. But the idea that you can give away the individual incapable's money during lifetime is something that is done a lot. And this legislation specifically expressly allows for gifting to continue as it has historically been done. So that's a big difference between looking at the will, seeing that, oh boy, your grandkids are all going to get 100 grand each. So there's lots of money here. Why don't I give the 100 grand each to them now? That's almost certainly not allowed. But the idea that you always gave to Salvation Army and Heart and Stroke every year, and you continue those gifting or to the church or whatever, the legislation gives the attorneys, it gives you the flexibility to continue that. And it's the cases that have tested it typically are just looking at what is the history of giving, and is it in the relative range of what was being given before.
Yeah,
So,
and certainly
yeah,
in
go
my
ahead.
experience, Ian, that it's a dangerous game in many cases, because you do want to make sure that it is just a continuation of a previous history of gifting. Trying to rejig an estate plan by gifting, a very big dangerous game to play, particularly because we've got the public guardian and trustee that's going to be watching over our shoulders, and we want to make sure that we're not offside. And so in situations, I've seen attorneys actually, if they're going to consider a large gift and want the comfort of knowing that they're not going to get criticized at the end of the day, they can seek the advice and a direction of a court and have that essentially blessed. But that's going to be, with the PGT involved for sure, and making sure that there are sufficient assets, that there is sufficient evidence to support this history of gifting. And you sort of do so at your own peril, I would say, notwithstanding the fact that the legislation lets us. You want to make sure that you are doing it carefully and really have thought it through, because we just never know how long someone's going to live and how much they're ultimately going to need, even when there is a large pool of money.
Absolutely. So we've talked a lot about what we have to do, what happens if we don't do it, and what are the kind of exposures and liabilities that exist. And that, of course, is set out in Section 33 of the Substitute Decisions Act, which gives you the area of parameters of liability. And the first most important is, of course, like an executor or like any fiduciary, but like an executor, a guardian of property is liable for damages resulting from a breach of the guardian's duties. And that's a personal liability as a fiduciary. So that's a sort of an expected. But Susanna, there's a carve out for that under Section 33 sub 2. Do you want to just speak to that?
Sure. That provision provides that if we can satisfy the court that the attorney has committed a breach of duty, but nevertheless, when they did so, they were acting honestly, reasonably, and diligently, there is an opportunity for the court to relieve the attorney from all or even part of that liability. So it seems like a recognition of the fact that, we've got people doing good for goodness sakes, and as long as they're doing it guided by the best interests of an individual, there could be this exculpatory provision that could protect the guardian or the attorney in those situations.
And then, what we've kind of looked at what sort of exposure we have and what we have to do. Certainly, what we're entitled to do. And one of the things that I get asked from time to time is if there's a transaction that's already in play, does an attorney have the ability to continue it if it was entered into by the incapable? And obviously there's no hard and fast rules, but on balance, it's yes. The answer is yes, and you can continue the transaction. But what you can't do is change beneficiary designations, and that's been sort of discussed at length. Descharnes and TD Bank case and the and subsequent cases since then, where it was considered as to whether or not you were able to change designations of beneficiaries, and then first certainly on a life insurance, and it was determined that you cannot.
And the reason for that, of course, is because, we've always been taught that an attorney can do anything for an incapable person but make a will. And in that decision, the Deshawn decision you just mentioned, Ian, I mean, that was the analysis that was done there. Is the court recognized that, you know, when we're making a change of a beneficiary designation of life insurance or some other plan, that it's a testamentary kind of transaction. The designation only comes to life when someone passes away. And so it's sort of on par with making a will. So those two things, you know, I think it's pretty clear in the cases. There are some, you know, outliers in that, but for the most part, we certainly can't do that as an attorney for property for an incapable person.
And the idea that was raised in the chat is, and the legislation speaks expressly to this. So if there is no, if you look at the will, you're the attorney and you look at the will and you see specific gifts all over the place, or the house goes to the grandchild, but it's the only asset during lifetime that's available for liquidation, the legislation expressly and the case law expressly relieves you of that, and you're not. So what I always say is you have to be mindful of the gifting under the will. You're not compelled to follow the gifting, and certainly in a situation like the question raised is that you're in a case where you just have no other assets to liquidate to fund the care costs. You can do so.
That's right, but we want to make sure that we're keeping track of the proceeds as well too, and for, you know, if it turns out that someone was entitled to, you know, the house, and that we want to make sure that the funds are earmarked as the proceeds from the sale of the house, because the legislation then allows the beneficiary to be entitled to those funds on death.
Another area that I see more and more, and certainly with an aging population, is in terms of what you can do, is the idea of settling alter ego trusts. That's a tool that is obviously very handy for people over the age of 65. And that in and of itself, settling the alter ego trust or inter vivos trusts as well, you know, again, hard and fast rules don't exist, but generally speaking is allowable. Where it gets dicey, I would say, is where there's a certain estate freeze planning, and that it depends on the structures, but certain estate planning estate freeze planning is allowable and has been tested by the courts in that regard by an attorney.
Yeah, for the most part, in any of those situations, the idea is that, you know, you can do it as long as you're not changing the ultimate beneficiaries from those that would take under the will or an intestacy. So that's really the guiding force behind allowing these transactions to be done, this kind of estate planning to be done on behalf of an incapable person, as long as we're not upsetting the ultimate beneficiaries.
And you know, we talked about using advisors and the expectations of using advisors. Under the Trustee Act, which is expressly excluded, the expectation is that you will hire an advisor, an investment advisor, and get advice from time to time on your balanced portfolio analysis. But it's similar in a sense. I mean, I've had this debate before as to whether or not advisors need to be involved with attorneys' accounts, and my general observation is yes, because you know you can get advice on what kind of portfolio is best in light of the exclusion to the Trustee Act. But one thing's for sure is tax accountants, account lawyers if needed, all of the sorts of resources that you would normally expect an individual who is capable to seek out can and should be sought out in respect of any of the advisors that you're going to be working with. All right, so I'm just going to check the last chat here to make sure if we have any other questions. And sorry. So the idea of estate planning, the question is for a client who requires multiple wills, do you suggest that preparing additional powers of attorney for property relating strictly to the business? And that's a great question, because that's the short answer is yes. And often I will see it with certainly lawyers, for example, with their professional corporations. You need to have a lawyer who's going to be the succeeding attorney for it, and you can't, if you have to be careful as to who you expressly appoint. The Law Society has great materials on that in terms of precedent materials on when you're setting up professional corporations and what to do. But corporate planning always needs that to be considered. A blanket choice of an attorney is probably not a good idea, and certainly in complex planning needs to be considered.
Mhm.
All right, well, look, I think looking at the wrong screen here. I think we're just about wrapped up here for today. Susanna, thanks so much for your
Thank you.
help, and Jordy will be back next week. And thanks everyone for joining us, and have a great weekend.
Thanks, everyone. Take care now and have a great day.